The Bombay High Court has refused to condone a delay of 73 days in filing revision petition, observing that liberal interpretation of sufficient cause cannot counteract want of diligence, as it took the litigant 5 days to recover from jet lag. The court was considering a petition filed challenging trial court order that rejected an application seeking condonation of delay of 73 days in filing a revision application under Section 201B of the Goa Panchayat Raj Act, 1994. The bench of Justice Nivedita P. Mehta held there is no infirmity in the impugned order and that a liberal interpretation of sufficient cause cannot be harnessed to counteract a want of diligence on the part of the petitioner. At the outset, it is pertinent to understand the value that may be placed on the consideration of the quantum of delay. In Mool Chandra v.S. Union of India under .6, a division bench of the 2025 एक SCC 625 Hobieli Supreme Court has summarized the principle as extracted hereunder for convenience. It is not the length of delay that would be required to be considered while examining the plea for condonation of delay, it is the cause for delay which has been propounded will have to be examined. If the cause for delay would fall within the four corners of sufficient cause, irrespective of the length of delay, same deserves to be condoned. However, if the cause shown is insufficient, irrespective of the period of delay, same would not be condoned. In Pathpati Subba Reddy, died by L.Rs and ORS. Versus the Special Deputy Collector, La, Supreme Court held that the provisions of the Limitation Act have to be construed differently, such as Section 3 has to be construed in a strict sense whereas Section 5 has to be construed liberally. Courts are empowered to exercise discretion to condone the delay if sufficient cause had been explained, but that exercise of power is discretionary in nature and may not be exercised even if sufficient cause is established for various factors such as where there is inordinate delay, negligence and want of due diligence. It is principally true that the relaxation from the timelines as prescribed by the law of limitation cannot be granted to those who sleep on their rights. Or as the district judge rightly said in the impugned order, this is not the conduct of a prudent man, the court observed. Noting that although the law of limitation is rooted in public policy, and the spirit would dictate that the legal rights ought to be enforced in a court of law within a time frame, and that litigation cannot be permitted to be suspended in a state of endless continuity, the court stated that an argument for a liberal construction of sufficient cause cannot be used to jettison the law of limitation itself. The petition was accordingly dismissed.